The opinions of the court in two cases, number 85-1358, Lukhard against Reed, and number 85-6756, Hitchcock against Duggar, will be announced by Justice Scalia.
Fourth Circuit. In 1982, Congress amended the statute governing aid to families with dependent children. That amendment provided that a family that received a large amount of income would be ineligible for AFDC payments for as long as that income would last if the family spent no more than a state-prescribed amount each month. In response to the amendment, the Virginia Department of Social Services revised its regulations to define various lump sum payments, including personal injury awards, as income. It did not, however, alter regulations categorizing the proceeds of the sale or conversion of real or personal property, including property damage awards, as resources rather than income. Respondents who had received personal injury awards and were rendered ineligible for AFDC payments as a result of Virginia's revised regulations brought a class action in federal district court. The district court granted summary judgment in the class's favor, holding that treating personal injury awards as income was inconsistent with the federal AFDC statute, and that treating them differently from property damage awards was irrational. On appeal, the Court of Appeals for the Fourth Circuit affirmed. We granted certiorari to review that decision, which conflicted with the decision of the Seventh Circuit. In opinions filed with the clerk today, the Court reverses. I have written a plurality opinion, which has been joined by the Chief Justice and Justices White and Stevens. We conclude that Virginia's decision to treat personal injury awards as income is lawful. The term income is not defined in the AFDC statute, and it can quite naturally be used to mean any money that comes in which sense it clearly embraces personal injury awards. Moreover, Virginia's revised regulations are supported by the deference owed to the conclusion of the Secretary of Health and Human Services that the AFDC statute permits states to treat personal injury awards as income. Finally, it is not irrational for Virginia to treat property damage awards differently from personal injury awards, since, unlike personal injury awards, property damage awards generally do not increase the amount of real and personal property held by their recipients. Justice Blackmun has written an opinion concurring in the judgment. Justice Powell dissents in an opinion joined by Justices Brennan, Marshall, and O'Connor. Hitchcock versus Duggars comes to us from the 11th Circuit. Petitioner was convicted of first-degree murder. At his sentencing hearing, the trial judge instructed the advisory jury not to consider evidence of mitigating circumstances not specifically enumerated in the Florida death penalty statute. The trial judge also refused to consider such evidence himself. Petitioner was sentenced to death. Following unsuccessful appeals and state and federal collateral proceedings, petitioner applied for writ of habeas corpus in federal district court, claiming that his sentence was invalid because the advisory jury and the sentencing judge had not considered evidence of non-statutory mitigating circumstances. The district court denied the application, and the Court of Appeals for the 11th Circuit affirmed. We granted certiorari and now reverse. Petitioner was sentenced to death in proceedings that did not comport with the requirement of our cases that the capital sentencing authority may neither refuse to consider nor be precluded from considering all relevant mitigating evidence. Under the circumstances of this case, petitioner's death sentence must be vacated. The case is remanded, and the district court is to be instructed to issue a writ of habeas corpus unless the state lawfully resentences petitioner within a reasonable time. The court's opinion is unanimous.
The opinion of the court at number 84-6811, McCleskey against Kemp, will be announced by Justice Powell.
This capital case is here from the Court of Appeals for the 11th Circuit. The case involves the relevance of a complex statistical study in Georgia that indicates generally that racial considerations may enter into the capital sentencing process in some cases. In 1978, McCleskey, a black man, was convicted in Georgia of murdering a white police officer during the robbery of a store. Under Georgia's bifurcated sentencing procedure, the jury recommended the death sentence. It found two statutory aggravating circumstances to exist beyond a reasonable doubt. McCleskey offered no mitigating evidence. The court followed the jury recommendation. McCleskey's conviction and death sentence were affirmed on appeal by the Georgia Supreme Court. In his habeas corpus petition in federal district court, McCleskey argued that the entire Georgia capital punishment system is administered in a racially discriminatory manner based on the race of the victim and to a lesser extent on the race of the defendant. McCleskey supported his claim with a complex multiple regression analysis called the Baldus study. The district court held an extensive evidentiary hearing on McCleskey's petition. It concluded that McCleskey had failed to show unconstitutional discrimination against him. It found also that the Baldus study was statistically flawed. The Court of Appeals for the 11th Circuit, sitting in bank, assumed the statistical validity of the Baldus study. It nevertheless held that McCleskey had not demonstrated that his sentence was imposed in an unconstitutional manner. For the reasons stated in an opinion filed today, we affirm, we hold first that under the Equal Protection Clause of the 14th Amendment, McCleskey must prove that the decision makers in his case acted with a discriminatory purpose. A wide range of variables necessarily enter into any capital sentencing determination. These must be considered by the prosecutor in exercising discretion whether or not to prosecute. In the end, the collective judgment of a jury determines the sentence. The generalized statistics of the Baldus study fail to raise an inference that McCleskey was discriminated against on the basis of his race or the race of the victim. The study also fails to support McCleskey's claim that his sentence is arbitrary in violation of the Eighth Amendment. In Gregg against Georgia, this court held that the Georgia death penalty procedures properly channel a sentencing jury's discretion. McCleskey's arguments are best presented to legislative bodies. Capital punishment is the law of the land in more than two-thirds of our states. Congress also has authorized the death penalty for aircraft piracy. It is the duty of courts to determine on a case-by-case basis whether these laws are applied consistently with the Constitution. Despite McCleskey's wide-ranging arguments that basically challenge the validity of capital punishment in our multiracial society, the only question before us is whether, in this case, in which McCleskey's guilt is not questioned, the law of Georgia was properly applied. We agree with the District Court and the Court of Appeals for the 11th Circuit that this was carefully and correctly done in this case. Justice Brennan has filed a dissenting opinion in which Justice Marshall has joined, and in all but Part 1 of which Justices Blackmun and Stevens have joined. Justice Blackmun has filed a dissenting opinion in which Justice Marshall and Stevens have joined, and in all but Part 4B of which Justice Brennan has joined. Justice Stevens has filed a dissenting opinion in which Justice Blackmun has joined.
The opinions of the court in three cases, number 85-1370, Arkansas Writers Project versus Ragland, number 85-1385, United States versus General Dynamics Corporation, and number 85-1530, Brock versus Roadway Express, will be announced by Justice Marshall.
85-1370 Arkansas Writers Project is an appeal from the Arkansas Supreme Court. There the appellant publishes a general interest magazine. And under Arkansas law, general interest magazines are subject to sales tax, but newspapers and religious, professional, trade, and sports journals are exempt from tax. The appellant maintained that this was discriminatory taxation in violation of the First and 14th Amendments. But the Arkansas Supreme Court rejected this claim. We reversed the judgment of the Arkansas Supreme Court and remand for further proceedings. Justice Stevens has filed an opinion concurring in part and concurring in the judgment. Justice Scalia has filed a dissenting opinion in which the Chief Justice joins. In number 1385, U.S. versus General Dynamics, comes to us from the United States Court of Appeals for the Federal Circuit. The Court of Appeals there held that an accrual basis taxpayer that provided medical benefit to its employees could deduct an estimate of its obligation to pay the federal care obtained during the last quarter of the year, claims for which had not yet been filed as of the close of the tax year. In an opinion filed with the clerk today, we reversed the judgment of the Court of Appeals. Justice O'Connor has filed a dissenting opinion in which Justice Blackmun and Justice Stevens have joined. The last case, Corp versus the Roadway Express Incorporated, is an appeal from the judgment of the United States District Court for the Northern District of Georgia, which court held unconstitutional Section 405 of the Surface Transportation Assistance Act. We hold today that the Act does not deprive the employer of due process by failing to require a full evidentiary hearing before the temporary reinstatement is ordered, so long as the employee is given an opportunity to respond to the Secretary's evidence and a prompt post-reinstatement hearing is available. We therefore affirm in part and reverse in part. Justice Blackmun, Justice Powell, and Justice O'Connor joined this opinion. Justice Brennan has filed an opinion concurring in part and dissenting in part. Justice Stevens has filed an opinion concurring in part and dissenting in part, in which the Chief Justice and Justice Scalia join. Justice Stevens has filed an opinion dissenting in part.